1.
The clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals is now in session.
We're ready to hear argument in cause number PD-0928-20, Baltimore versus the state of Texas.
Thank you, Judge. Good morning. Jesse Freud for Appellant Baltimore, and may it please the court. Mr. Price for the state. The court has granted review of the question presented in appellant's petition, which is, must the state offer proof of the parameters of a licensed premises to secure a conviction for the third-degree felony of unlawful carrying of a weapon on a premises licensed to sell alcohol? The answer to this question should be yes. If the court agrees, the remedy, which I need to correctly state because I didn't in my brief, is to reform the judgment to that of the lesser Class A misdemeanor. I didn't do that in my brief, so I need to fix that before y'all this morning. Before answering the ultimate question, though, the initial step is regarding deciding the correct definition of premises. And we've got two options, right? We've got the definition within 4602, and we've got the definition that was used in this case, which is the definition in the Alcoholic Beverage Code section 11.49a. And there is an open question as to whether that definition in 11.49a or the 4602 definition, which again is separate and contains its own, applies. Because we didn't challenge the charge here, I think the court is confined to what was used, which is the 11.49a definition. I understand that the state's brief had said and interpreted something I said that suggested that the A2 definition is what should be used. And I've gone back to my brief and tried to check where I may have said that to give that impression, and I couldn't find it. And Mr. Price and I talked because I wanted to clear that up if it appeared that I was advocating for A2. But we didn't do that. And the reason we didn't do that is we did not challenge the charge. So I do not believe that our brief or petition should be read to have encouraged the A2 definition. If somebody sees something different, please tell me so I can correct myself.
I just would like clarification right at the moment. I didn't follow what you said. So you're saying that the court is confined to the penal code definition or the alcoholic beverage code definition?
There are two, and that's the question before the court, which is which should apply.
I thought you said that you didn't object to the jury charge and it included one or the other.
Correct, I didn't, but I still think if we're talking about a sufficiency challenge, we have to judge the sufficiency of the evidence against the hypothetically correct jury charge. And I think the court has the opportunity, because of the situation here, to comment on which definition should apply. So even though it doesn't necessarily govern the disposition specifically, there's still an open question that the court can comment on about whether or not that was the proper definition, even if it went uncharged. Does that answer your question, Judge?
Yes, and it just leads me to ask then, which definition was in the jury charge?
The 11.49a definition.
The alcoholic beverage code. Thank you.
Yes, ma'am. And so, right, if we're talking about judging the sufficiency of the evidence and we're talking about the hypothetically correct jury charge, we've got this open question that I think would be nice for everybody to have an answer, which is which should govern. I think the statutory history is interesting. The premises definition in the penal code went undefined until 2007. And so all we had till then was the 11.49 definition. And so I think the question, if the court decides to write on this, is going to be what impact the 4602 amendment had on the statute and the definitions, because the legislature knew about the Richardson case at the time the 2007 amendment came out, yet they chose to enact a different definition. And so I think this case presents an opportunity for the court to give us all some clarity on that. But regardless of the...
I'm sorry, finish your answer.
No, sir, I finished my answer. I'm ready. Thank you.
Well, what I wonder about is what, if anything, is the difference between a premises generally and a licensed premises? Does that make sense?
Yes, sir. And so I think, again, it's when we're talking about the offense here, the licensed premises under the 4602 section of the statute that he was charged is on a premises licensed to carry alcohol. And so, right, we do have the 4602 definition that talks about premises, including real property and a recreational vehicle, and then gives us a definition of a recreational vehicle. But that I don't think comports with the premises licensed to carry alcohol part. So I think we're talking about the licensed, a premises that is licensed to carry alcohol.
Well, I'm curious about that because, you know, I have to concede, I haven't spent a lot of time looking at liquor licenses or alcohol distribution licenses, but I wonder whether those licenses limit the parameters themselves, whether they say, for example, you know, the bar is licensed as opposed to the parking lot of the bar is licensed, and whether you think that might have any impact on how we ought to consider this case.
Yes, sir, I do. And the case that we actually pointed to consistently in our brief to the 10th, as well as our petition to your court, and then our brief on our PDR, talk about the Terry case. And in the Terry case, the evidence that was presented, which would, if had been done here, would have been legally sufficient. A TABC agent comes in on the Terry case and testifies about the parameters of the liquor permit to that premises. And so based on the Terry case, it says that a liquor permit should designate, like you just said, Judge, the parameters of the premises. And so that's what could have been done here. It's what's been done in the Terry case. So this would have been a really simple thing. And it seems like, based on the Terry case, a very routine thing to do and very routine information to have available that we could have had available here, that there's even been a guide for the state since 1992 is the or excuse me, let me tell you the right year of the Terry case. 1994, excuse me. So the Terry case has been around a while. So the state has had ample guidance to say, okay, what's our situation where we have had legally sufficient evidence in this case? Cool. We bring in the TABC agent, get our liquor permit, defines our parameters, and we're done. So this was a very simple, easy thing that I think the state had a guidepost and a map to see how they could have proved that, and they didn't do that here. And in the state's analysis, I think really when we're talking about, again, the ultimate question, what is the court going to be deciding? And I think it really comes down to, is mere proximity enough? Is the parking lot being right in front of the bar, is that enough to say it's a part of the premises?
So can I jump in and ask a question real quick?
Yes.
So don't most bars have a sign like by the exit that basically says like, don't, you know, you can't bring alcoholic drinks past this point?
It is my understanding those are posted. I do not frequent bars, and the state's exhibit 7 and 8 that are in the record, volume 8 of our reporter's record. There are photos. They're not great quality photos. I think there may be some legible sign that you can make out in those 2 exhibits. So the answer to your question is yes, I think those signs are present. What do we have in our record? That would be state's exhibits 7 and 8, but I don't think they're very clear where you can make that out. So I think that'll be up to the court to look at and see what you think of that evidence.
Because I mean, how does that play into the definition of premises? If I'm not allowed, I mean, it feels like the implication of that sign is you're only allowed to drink inside this licensed place. So if you go beyond the boundaries of that, you're no longer in that licensed place. So how does that play into the definition of premises in your view?
I think that's exactly why the state needs to prove the boundaries of the premises. I think that's exactly the reason why it's important. We also talked in our brief and our petition just about how commercial real estate really, right, can be a hybrid of mixed use properties, right? You can have a bar that is maybe privately owned, leased by the current tenant, and maybe the city still owns the parking lot. Maybe that isn't the boundary. Maybe the lessee doesn't have any control over the parking lot. And so for kind of practical commercial real estate reasons, as well, Judge, is the reason you just pointed out. This is why it's really important for the state to prove up what the boundaries are and why it was an issue that they did not do that here.
Could I step in here and ask you a question? This is to kind of follow up on what Judge Uri asked, and I think really you've already answered this, but I want to try to make it clear. In Penal Code 4602C, it actually uses the term premises license. It doesn't say licensed premises. So are you reading that to mean that to be a premises licensed that the parking lot needs to have been mentioned somehow in the licensing process.
Yes, sir. I agree. And I think yes, I think that would be consistent with what we're talking about. And that phrasing on section C, I think would be consistent with the conversation we're having. Does that answer your question?
It certainly does. Thank you.
Yes, sir. So getting back to what the state's analysis is and talking about this issue of proximity, I'm not going to come here and tell the court that there wasn't evidence in the record that the photos, right, that the parking lot was right in front of the bar. That is in the record. And if you think that mere proximity of that parking lot is enough, then you need to affirm what the Waco court did, and the evidence would be legally sufficient. But I would really caution the court about doing it for all the reasons we're talking about now. And again, coming back to the Terry case, this is an easy thing to do. To not do it can create the ambiguity issues that we're all talking about here, which is where does the boundary start and where does it end, right? And even if we are talking about the difference between misdemeanor and felony conduct, right, we want to be able to draw that line for folks. Where really can't you be? Otherwise, you're going to be committing a felony. Yes, sir.
Can I just interrupt you for a second? I just had two questions on this. Is this bar, since I don't frequent bars either, is it part of a strip center in the real sense where there's other businesses there? Or is it kind of a standalone bar? And even if it's a standalone bar, when you're pulling into the parking lot, is there any kind of sign that says you're now entering onto a licensed premise, weapons prohibited, as opposed to just right at the beginning of when you enter the bar?
So that information isn't in the record either way, Judge. So I can tell you based on personal knowledge, but there was not that I can recall, and please ask Mr. Price the same thing so he can correct me if he disagrees. But I do not recall any testimony describing that would allow me to answer those questions for you. I don't recall any testimony about, there was testimony about the driveway and how one of the individuals involved in the altercation, their path out of the bar, and based on personal knowledge, it is my understanding and my recollection that the bar is standing alone, but I don't think that information is clear in the record before the court. But please ask Mr. Price and see if he disagrees. Excuse me. And so again, getting back to the state's analysis and this proximity issue, the state's brief on pages 15 and 16 seems to equate proximity with belonging and ownership and control. And again, if the court thinks that those are all the same, then what you do is you affirm. But for the reasons we're talking about, I think that that is conflating, again, just proximity and making a huge leap between proximity and ownership and control, which again, all were not shown based on the trial testimony. There were conclusory statements that the parking lot is a part of the premises with none of the Terry-like testimony that we should have seen and needed to see to have legally sufficient evidence on the third-degree felony for which Ijah was convicted. And because I've got about 60 seconds left, I'll return the time to the court and come back in rebuttal if I need to. Thank you all.
Thank you, Counselor.
May it please the court. My name is Gabe Price with the McLennan County District Attorney's Office, and I'm representing the state of Texas in this matter. I agree with Ms. Freud that the first step in a sufficiency analysis is to construe the statute, and to do that, we're going to have to discuss what the proper definition of premises is. But I think looking at 4602 subsection C, when it talks about a premises licensed or issued a permit, that's different than just premise by itself. You have to construe the phrase and not just the word. Subsection A-2, which is what's been called the definition of premises within the statute, isn't actually a definition. It only adds to the definition of premises. It says a premises includes real property and a recreational vehicle that's designed as living quarters. It doesn't say that a premises is or a premises means. So A2 is not actually a standalone definition for premises. In this case, you have in order to get to the felony, it has to be a premises licensed or issued a permit. And so that would implicitly bring up Title III of the Alcoholic Beverage Code, which is the 11.49A definition. And there was questions about whether the parking lot is necessarily included in that or not. The definition under 11.49A includes all of the grounds, which the state's position is that would include the parking lot. 11.49B would allow a licensed premises to exclude a specific portion of the grounds from the permit. But there's no evidence in this case that anything was excluded from the permit. That would just
how are the customers to even know that are going to that location?
And
what isn't until they actually enter into the bar?
And Judge, I don't think that the knowledge is necessarily an element of premise. I think it's similar to a drug-free zone where there's no knowledge requirement or intent attached to whether the premises is a licensed premises or not.
Well, it would be different than a drug-free zone given the laws in this state on open carry and having weapons with you.
And absolutely, and it's not a crime. And it's not a crime. It's not a violation of 4602 to drive onto the parking lot with your firearm. You're allowed to keep that in your vehicle. That's the 4602A exceptions, which allow for it not to be it's not an offense if you're inside your vehicle or directly en route to your vehicle. And that was what this case was about. This case was about whether petitioner was en route to his vehicle. That was the entire defense. There was no discussion or argument really about whether the parking lot constituted a premises.
Mr. Price, here you got a motorcycle, and so if you can have it in your car, so if for instance the appellant was driving a car instead and got into his car and then grabbed his gun and put it on him, then you're saying that would be okay. But with a motorcycle, it's not so easy to do that. I mean, he's having to grab it out of the saddlebag and then put it on him while standing up because he doesn't have the room on his motorcycle to move around necessarily. And so how is that not really the equivalent of being, part like in his vehicle?
And I would agree that would be the equivalent of being either in his vehicle or en route to his vehicle. The evidence in this case, though, was not just that petitioner was putting his gun on while getting onto his motorcycle. He actually left his motorcycle, went over to Ty Johnson's car, pulled the gun out and stuck it in Ty Johnson's face. So that was the testimony of Ty Johnson, Davina Cook, and the two witnesses that testified that observed the what was called a tussle in the parking lot. So this isn't just him at his motorcycle. What created the offense was when he left his motor vehicle, left the motorcycle, was no longer en route or inside of, and went several spaces over to confront Ty Johnson. So I would agree with you that if he had stayed on his motorcycle, which was what his defense was, this would not have been a crime, would not have been a misdemeanor or a felony offense. But getting back, yes, Judge.
So here's what I'm wondering is if there's no evidence talking about or informing the fact finder about the parameters of the license, how far the license extends, maybe through potentially introducing a copy of the license itself or some person who's read the license explaining the parameters of that license, then how is any fact finder to draw a rational conclusion about whether or not the premises that the defendant was on was licensed or not?
Judge, I think in this case, the evidence in this case is that the customers were inside the bar. There's no dispute that the Crying Shame Bar is a premises licensed to sell alcohol. They were purchasing alcohol inside. They were drinking alcohol inside. I believe the defendant got on the stand or petitioner got on the stand and admitted that they were purchasing alcohol inside. There was testimony from an officer that it was, or really from all the officers, that it was a premises that the Crying Shame was licensed by this state and TABC to sell alcohol. So that testimony is in there. But the question is whether that extends to the parking lot. That's the controverted issue here, is whether the parking lot is part of the premises and under which definition are we to view that? Do we view that under the 11.49A definition, which would include all of the grounds, and the state's position is the grounds includes the parking lot? It would be, the example of common sense of Walmart. If you're in the parking lot of Walmart and somebody asks where you are, you would just say, I'm at Walmart. You're not gonna say, I'm in the parking lot of Walmart waiting to go into the premises of Walmart. That just is not the way common sense would really talk about that issue. And in this case, you have every single witness testifying that that parking lot was the parking lot of the Crying Shame, of the bar that was selling alcohol. You even have the defendant or the petitioner getting on the stand and testifying that it was the Crying Shame parking lot. So there was really no question or no argument or contrary evidence that the parking lot was the Crying Shame's parking lot.
Mr. Price, most bars have a sign that say no alcohol beyond this point when you're leaving the building, when you're walking out the door to go to the parking lot, no alcohol beyond this point. Did the Crying Shame have any such sign?
That is not in the record. I'm not sure of that. I haven't personally been inside the Crying Shame. I've driven by it plenty of times, but not inside. I would say I don't think that whether there's a sign that's the bar's rules of not taking alcohol outside necessarily defines what the premises is. Because the premises, the way I wrote my brief, I really think there's only two options as far as the definition of premises, and that's the 11.49 premises definition or the common definition, because I don't think we can use the A-2 definition under this section. And I think when you look at that, you also have to compare that to the definition of premises that's in 46.035. When the legislature added that definition, they specifically limited it to building or part of a building, and then went on to specifically exclude driveways, sidewalks, and parking lots. Because the legislature felt the need to specifically exclude parking lots from the definition of premises under that specific section, that would imply that parking lot would be part of the definition of premises elsewhere. Otherwise, there'd be no need for the legislature to have limited it in 46.035F. And in this case, I think when we look at what the purpose behind 4602 sub C is, it's designed, we know there's a heightened dangerousness or potential for violence or dangerousness with alcohol involved. And the fact that alcohol is being served inside the bar, people are necessarily going to be coming out of the bar and into the parking lot. And I think in this case, when you look at State's Exhibit 8, which is the photograph of the petitioner's motorcycle, how close they are to the front door, really the property is one continuous property. And I would also kind of refer this court to the previous decision in Chiharini, which was the case about the condominium complex and whether the common areas were part of the premises of the petitioner in that case. And this court held that premises has a very broad definition and includes really any business or commercial or residential property. So looking at the broad definition this court's given premises in the past under, that was a 4602 subsection A case, not subsection C, I would urge this court to adopt if it's not going to follow the 11.49A definition, to adopt a common meaning definition that was similar to the one used in Chiharini, which is.
I'm sorry, I am still having some difficulty with your argument in the sense that it seems like you argue that if it is a premises, then, and the premises has a license, that therefore all the premises is a licensed premises. And it seems to me that licenses don't work that way, you know. I could be wrong about my
and Judge,
gut instinct about this, but I'm concerned that there may be limits on the parameters of a license that don't necessarily directly correspond to the breadth of the definition of premises, no matter where you find it. And so,
I think, sorry, go ahead.
No, I'm ready for you to answer now.
And so I think that goes back to, I don't think the license, my view of licenses, all it does is list the address. It doesn't list a specific building. Unless a licensee or a permittee has specifically designated parts of that premises or the grounds not to be included, then the entire grounds are included in every permit issue. And that's because the permit is issued for the premises, and the premises is defined by 11.49A, which will include all the grounds, structures, vehicles, and appurtenances, and then it would also include adjacent premises. So the fact that the license here would not necessarily exclude the parking lot. Now, there's a potential that it could. However, the fact that there may be some evidence that would support a defensive theory in this case doesn't go against the evidence that was presented in this case.
If the way I'm thinking, and I could be off base here, but if it was required to get a license, to have a licensed premises, that you include everything, the driveway, the whatever, you wouldn't need the definition in the alcoholic beverage code, right?
No, Your Honor, I think the definition in the alcoholic beverage code is what makes by default the license apply to the entire ground.
Right. But I'm saying if the requirements to get a license in the first place said you better put in here everything that you're including, okay? If it required that, you wouldn't need that definition.
That's correct. And because it allows for the exclusion of property, that's why that definition is there. And then there's a potential for exclusion. But there's no evidence in this case that anything was excluded from the property or the grounds of the crying shame. And I think when we look at this case and look at the evidence of this case, when we're talking about sufficiency, Ms. Freud talked about mere proximity. And mere proximity by itself, I don't think is enough. And I would agree with her there. However, mere proximity would be a factor in determining whether it's part of the premises, whether it's part of the grounds of the crying shame. And in this case, when you have everybody testifying, this is the property of the crying shame. This is the crying shame's parking lot. I think that is evidence that a jury can rationally rely on to say, yes, this is evidence of a parking lot. And I know I would refer this court about a month ago came out with Curley, which was a playground case in a drug-free zone. And in that case, it held that the officer's plain statement that the playground was open to the public was not sufficient. However, the fact in this case of whether the parking lot is part of the property and premises of the crying shame is more like whether that playground was on the church's property, which nobody seemed to have any issue with that testimony. The officer testified, I think in that case, that it was about 538 feet from the location of the stop, and it was on the church's property. That's an observable fact from the witnesses at the scene. So the witnesses that testified here as to the crying shame, the parking lot being part of the crying shame's property, were able to observe that property. It's when you drive by something, you can tell, I think in common knowledge, whether a parking lot is part of that business's parking lot or not.
Mr. Price.
Yes, Judge.
When businesses are allowed to put up signs that say that you're not allowed to either carry concealed or carry openly here, and that's on the door as you walk in, providing notice to people that you have to return your gun to your car if you want to come in. How would that really be different then as far as premises go, as for notice for someone who can't bring a gun into a particular location?
Yes, Judge, that would be a different statute. That would be the statute for criminal trespass when you have that 3006 or 3007 notice. So that's if you're being charged for a criminal trespass for taking your firearm on there. That's when that would be implicated. Or
notice as to the parameters. So that's parameters of where you can carry your weapon. So it seems to me this would be a similar situation where you'd have to provide notice of what constitutes the premises of where you can carry.
And I think with the criminal trespass statute, you have that specific notice requirement. Under the unlawful carrying of a weapon statute, you do not have a specific notice requirement as far as whether the premises is licensed. Also, I would think that because everyone is charged with knowledge of the law, and 11.49A would have the definition of premises. And I think you would have an idea that the bar you're going to buy alcohol is licensed. And because that includes all of the grounds on there, that the notice would be provided under the law under 11.49A, is including all of the grounds and structures thereon. So I think the notice is provided that way, but there's no requirement under 4602 sub C that there's notice given to the defendant that it is a licensed premises.
Besides, where would that notice be? At the end of the driveway, or, on a tree next door? Or, do people have to take a tape measure when they're going there to figure out where the, premises are? I mean, I don't know if notice on the door would satisfy notice of the premises.
And I agree with that. And I think that's why this is a common sense type argument, where it's common sense that a bar is a licensed premises. And if you're driving to the parking lot of the bar, that is part of the grounds or property of that bar. Now, you can keep your firearm in your car when you're going there, but if you're leaving your vehicle or your motorcycle for a reason, such as in this case, to go get into a fight and pull your gun on somebody, that's when you're going to be committing the crime. If you're a licensed holder of that firearm, then if you're concealing that firearm while walking around the parking lot, you're still not committing an offense, because 4615 would make that non-applicable. 4602 is not applicable if you're carrying a firearm concealed in accordance with the 411 of the government code.
Mr. Price, I have a question for you. And to ask this question, I need to tell you what I think, which I usually don't do that in oral argument. But I do think that this case is pivotal on whether or not the prosecution presented evidence that this bar was directly or indirectly under the control of the same person, or the bar. And I think to do that the state needs to have introduced evidence that this parking lot was for the bar only. I think that without evidence that it was only for the bar, it's going to be hard to meet that burden. So was there evidence that this parking lot was for the bar only and no other businesses?
And Judge, I don't believe that the evidence is specific that is only for customers of the bar in those direct terms. I also I'm going to respectfully disagree that the parking lot has to be only limited to those bars' customers. I think that if it's the grounds of the bar, if it's the property of the bar, which there is testimony that it's the property of the bar, that doesn't implicate the second section of 11.49A, which is the adjacent premises. It's part of the same premises, so it doesn't have that secondary requirement of needing to be under the control of the same person.
Yeah, okay. I understand what you're saying, and that's why I told you what I think. I do think that that it's going to have to be indirectly or directly in control of the same persons, which would be the bar owner. That's the way I read the statute. And if I'm correct on that, and I may not be, then I think that to do so, just introducing evidence that the bar used the parking lot and maybe other people did, doesn't meet that burden. So if there's anything you can think of that would meet the burden that I think has to be met, I'd like to know what it was.
And Judge, real briefly, I think the jury could rationally infer that it was under the control of the bar when every witness testified that it was the bar's parking lot. That's where they parked to go into the bar. That's where all their vehicles were. The owners were able to keep people inside the bar, doing a control of that scene to help the police officer. So I think there is enough evidence for there.
Okay, thank you.
Okay, your
Thank
time
you.
is
No
up.
more questions.
Thank you, Council.
Thank you.
I'm going to try and start where Judge Walker left us with that. I was going to say, let's walk through the facts that the 10th relied on to say that there was control of the parking lot, because I think that might go to what Judge Walker wants to know, which is what's in the record that would support the parking lot being used only for that use. So let's go through it. It's on page 6 of their opinion, and it says Ty Johnson and his girlfriend both testified that the altercation took place in the parking lot. Does not show sole ownership. Okay, so that's one fact. Second one, 2 law enforcement officers testified that the offense occurred in the parking lot of the Crying Shame. I think that's the same information as Ty Johnson and Davina. So does not show what Judge Walker's talking about either. The next one, is specifically one of the officers testified without objection that the parking lot was included as part of the premises. That's Detective Williams' testimony on page 97 of volume 6. And what his testimony was, I'm going to read it to you so we can be clear on what it said. And question was, and then included as part of the premises of the crying shame, that includes the parking lot. Detective William answered yes. The follow-up question, and the legal definition of premises for purposes of this statute includes the parking lot. The answer to that question was yes, but it still doesn't go to what Judge Walker just said, which is the control element, that you have to show, right? You have to show that the parking lot is either one, actually part of the grounds of the licensed premises owned or leased by the lessee, and the witnesses, the 3 witnesses we just went through, the officers didn't talk about that, and Ty Johnson and Davina Cook wouldn't have even had that information, right? So that wouldn't have even have come from them. They're not going to know that. And then the second is under the direct or indirect control of the licensed premises, which is what Judge Walker's talking about. And that testimony by Detective Williams is clearly conclusory in nature and does not talk about sole ownership or sole control. And so we're back to our 2 last facts, which is going to be the photographic evidence, states 7 and 8 that we talked about, where I explained it does show that the parking lot is right in front of the bar, right? But we're talking mere proximity is not enough. And it actually sounded like Mr. Price says he agreed. So maybe we have more agreement than we think. But the last point that the 10th made is that the management of the crying shame exercised some degree of control over the parking lot by preventing the patrons from going on the premises where the investigation is going. This is why so many things are above my pay grade. That's going to be, I can't wait to see how y'all explain to me how that shows control or indirect control. I will wait, and I can't wait for you to explain that to me. I'm at a loss. I got nothing.
Well, isn't that at least some circumstantial evidence that they had control? How are they going to shut down a parking lot if they don't have exclusive control of it? If other people are using it, it sounds like they're really stepping on some other businesses' feet.
Well, it was control for the purposes of when law enforcement arrived, and I think that's pretty typical in any circumstance where there's a call for service and law enforcement, essentially asks for cooperation from people who have some apparent authority to contain a scene. And so I look at that as just basic law enforcement scene management and not a fact that shows that indicates parking lot ownership. But Judge, if you say it does, then maybe that's the answer to my question. Maybe that's what shows it.
Well, I'm only one judge, and I'm not sure I'm saying that. I'm just asking you.
So then we've at least gone through everything that the 10th said they relied on. And then again, just going back to what Judge Walker has us talking about is then maybe that's the one fact. If that's the one fact, that's the one fact. But everything else that they relied on, there's 2 witnesses that wouldn't have even have had that information. The detective who testified, that testimony is conclusory in nature and does not talk about the direct or indirect control that needed to be shown. And again, if mere proximity isn't enough, which is what Mr. Price said he agrees with, then I think we actually may have more agreement here than we realized when we started. And so I will return my remaining 3 minutes to the court. Thank you for your interest in this issue. And I would ask that you reverse the judgment of the Court of Appeals and reform the judgment to the lesser of that of a Class A misdemeanor. Thank you for your time.
Thank you, Counsel. The case is submitted and the court stands in recess. The clerk will adjourn the court.
Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.